Birtherism. What does that mean? Birther. I'm a birther. I don't think that the birther thing has to do with necessarily where you were born. It could, but that's not the whole thing. I filed a lawsuit about birtherism. I think it's a matter of constitutionality. That's where we come down to. The people who were involved in the birther action don't necessarily have to do with where Mr. Obama was born, but the birth certificate that he put out, if it's actually a real birth certificate, is evidence that the birther issue should still be alive. Our Constitution was founded on certain principles, and it doesn't take just being a citizen. You guys like to use that word citizen. Oh, he won't say he's a citizen of the United States, but I'm sorry. Unless you were born 200 years ago, being a citizen isn't going to be enough to be the President of the United States. There's a certain phrase that's used in there, and apparently the people that we have in Congress, since I'm listening to this Black Caucus with these people from the House of Representatives and senators, sitting here trying to tell you that we're all racist. Well, it's a complex legal issue, my dears. Maybe you ought to pay attention to history and know what the Constitution says. A matter of fact, Article 2, Section 1, Clause 5 says that no person except a natural-born citizen or a person who is a citizen at the adoption of the Constitution shall be able to be the President of the United States. I don't know anybody alive today that was a citizen at the adoption of the Constitution. So that only leaves one type of citizen that's eligible to the presidency. That would be a natural-born citizen. Natural-born, like Ted Cruz tried to say, oh, because he was born of a parent, one parent, in a foreign country, that makes him a natural-born citizen because he had a natural birth? That's not what it is. There's a definite meaning behind that. We have precedent, not so much in the final conclusion of a law case, but we have a Supreme Court justice giving you the proof of what a natural-born citizen is. He cites it very clearly. It's in our history. Let's go back and take a look. Let's just really be intellectually honest here, okay? Because in order for us to understand where we're at with this thing, there were certain reasons why the phrase natural-born citizen was used in the first place. And a matter of fact, that comes very clearly in a letter just 2 weeks before the Constitution was ratified and signed. There was a letter from John Jay, the first Supreme Court Justice of the United States, to George Washington. And it happened to say, and I have the letter here, let me read it to you, okay? It says here, permit me to hint whether it would not be wise and seasonable to provide a strong check to the admission of foreigners into the administration of our national government, and to declare expressly that the command-in-chief of the American Army shall not be given to nor devolve on any but a natural-born citizen. Okay, that's a pretty descriptive thing. The reason behind it was that they didn't want foreigners. You have to understand that at the time that letter was written, we had just come out of a war 11 years previous, fighting against the English. Do you think we didn't have English people still living here in the United States? This is a history class, folks. Pay attention. We had just got done fighting a war against the English. We ourselves, at that time, were English citizens until we broke away and declared our independence in 1776. Therefore, the people who still remained on the continent of the United States, North America, Some of them were British. They continued to be British subjects because they declared that they didn't want to be American citizens. We allowed them to stay with the intent that they could live here so long as they didn't cause problems. But we certainly didn't want them to be allowed to become the president of the United States. Otherwise, we'd have been under British rule again. We would have went from British rule to British rule. So we had to put a strong check in there to ensure that only a person who was loyal to the newly found country could be allowed to be the president and commander-in-chief. You don't want to have somebody inside of your government that's running the country in charge of the army to turn against the people who were already founding the new country. That's pretty simple to understand. The reason that they said natural born citizen was because they understood it what it to be. We have to understand that in history, it tells us a lot about where their minds were at. There's another letter that was sent previous to the Declaration of Independence. That letter was sent in 1775. We signed our Declaration of Independence and sent it over to England in 1776. But in 1775, Benjamin Franklin wrote a letter to a guy named Charles Dumas. And let me read that letter to you so you understand the nature of things, the reality, the intellectual whereabouts of where people were in this country. Benjamin Franklin wrote this letter, and I'm going to read it to you and quote it. Dear Sir, Philadelphia, 9 December 1775. I received your several favors of May 18th, June 30, and July 8th by Messrs. Valiant and Porchard, whom, if I could serve upon your recommendation, it would give me great pleasure. Their total want of English is at present an obstruction to their getting any employment among us. In other words, they couldn't speak English at the time. But I hope they will soon obtain some knowledge of it. In other words, he wanted to hope that the people who gave the gifts to him, who were seeking employment in the United States, who happened to not speak English, he was hoping that they would be able to gain knowledge of the English language so that they could find employment. But he was still thanking him for this gift. Here's the gifts. This is a good country that artificers are farmers, but gentlemen of mere science in les belles lettres cannot so easily subsist here, there being little demand for their assistance among the industrious people who, as yet, have not much leisure for studies of that kind. In other words, he's telling them that these intellectuals that were sent there to give them these books as friends couldn't find employment because they couldn't speak the language, and they were educational people, things that weren't needed in the United States at the time because we were an industrial people. We were people who were trying to build a country, and our needs weren't for people who were going to sit out there and espouse great thought patterns. We needed people who were people of action at the time. Let me continue the letter. I am much obliged by the kind present you have made us of your edition of Vital. It came to us in good season, when the circumstance of a rising state make it necessary frequently to consult the law of nations. That was the gift. The book called the treatise. The book called the Law of Nations, or God's law, or the natural law. It was a gift that Dumas had sent Benjamin Franklin of copies of Vital's treatise called the Law of Nations. Okay? So we got to understand that he's saying here, it came in good season when the circumstances of a rising state. Well, what would that rising state be that he's talking about? This letter was written in 1775. In 1776, well, guess what? we filed a Declaration of Independence. So what do you think the rising state was? The rising state was the United States. We were rising against our oppressor, which was the English. Okay? So it came in good season when the circumstances of a rising state make it necessary frequently to consult the law of nations. Why would they be consulting the law of nations? Because that treatise, the law of nations, was about how countries were created, how they were to interact with other countries, how their citizenry would work, how their boundaries would work. It was all about it. It was a very well accepted book which told all nations how they were supposed to interact with each other. And in order for us to set up a country, we needed to be able to have everybody else who was reading that book, which were all of the major countries at the time. We'd have to know how to talk to them, communicate with them on a grounds that had basis that they were familiar with because they were all reading the same book. Okay? So let me continue the letter. According to that copy, that copy, which I kept, Benjamin Franklin kept one for himself. You can check the history. He used to carry it around everywhere. It was with him all the time. After depositing one in our own public library here and sending the other to the College of Massachusetts Bay, as you directed, has been continually in the hands of the members of our Congress now sitting, who are much pleased with your notes and preface, and have entertained a high and just esteem for their author. In other words, he's saying that the notes and the letters that were the preface that was written for it was Mr. Dumas himself, and they found great esteem for him, but they were constantly referring to Vital's book. It's what it's saying. Look, we had a Congress at the time. This is history. We had a Congress at the time, and if you'll read the Declaration of Independence, you'll understand this. We had a Congress at the time that was mostly formed of English appointed senators, whatever you want to call them, a parliament, basically, even though we called it a Congress. But there were some people in there that were really sincere about our own new country. And when they wrote the Declaration of Independence, one of the things was, he said, you have instituted laws for us which are alien to us. We were being ruled by a country that wasn't here with us. They were overseas trying to tell us what to do. So he's saying here that the Congress that was sitting, which were people who also had a big hand in writing the Declaration of Independence, were constantly referring to the book, The Law of Nations. Okay? That's what he's saying. Let me read it again. History is history. You can draw it. You have to be intellectually dishonest not to understand what he's getting at here. He said, accordingly, that copy, which I kept, has been continually in the hands of the members of our Congress now sitting, who are much pleased with the notes of the preface and have entertained a high and just esteem for their author. Your manuscript, Idée sur le gouvernement et la royauté, is also well relished and may in time have its effects. In other words, that was another book that they were looking at, but the one that they were really following was Vital. So let's go on. Likewise, the other smaller pieces, which accompanied Vital, and he gives the names of those, being a very concise and clear statement of facts, will be reprinted here for their use of our new friends in Canada. The translation of the proceedings of our Congress are very acceptable. I send you herewith what of them has been farther published here. In other words, the archive, they had a recorder sitting in the congressional sessions and he was taking down notes, and they were printing them out. And those copies of those printed things were being sent to the people over in Canada, which were the newfound friends. And he was sending him back over to Dumas some of the copies of what they were talking about, because he was trying to let people know about what the United States was up to. Well, they knew soon enough. In 1776, in July, they filed the Declaration of Independence against the king and told him all of the things that he'd been doing that we weren't pleased with, and that we were now breaking away and forming our own country. The basis of that was based on the law of nations. Now, that's very important that we have this, because it was in the hands constantly. Well, what kind of things did it talk about? Let's go back to the other thing that I just had said, which was that just before the signing of the Constitution, the ratification of the Constitution of the United States, John Jay sent a letter to Washington telling him that we needed to put a strong check against the admission of foreigners into the administration of our national government, and that no person should be allowed to be the commander-in-chief of the armed forces unless he was a natural-born citizen. Okay, well, let's see. Where would they get that idea of what a natural-born citizen was? They would get that from the book, Vital, itself. Let me take my sunglasses off again, because I'm going to read to you what they were reading, why they would have put it in. And don't tell me you're intellectually dishonest if you don't follow this. If they had this book in their hands the whole time, and I'm going to read to you from that book, The Law of Nations, it says here in the 19th chapter at 212, citizens and natives. This is where they got this phrase. John Jay said, don't let anybody but a natural-born citizen be the commander-in-chief. He didn't say citizen, and that's not what our Constitution says. Our Constitution says natural-born citizen. It's a specific type of citizen. They were aware of what the term meant, and other people 100 years later were aware of what it was. We seem to have a problem with history, so we try to fool around with the meaning behind the words, like I said, Cruz trying to tell you that a natural-born citizen is any person born of one parent. John McCain trying to tell you that he was a natural-born citizen through Senate Resolution 511 because they said, well, there's no way that our founders intended to keep a person who was the son of a military person. Yeah, they did. Yeah, they did intend that. They intended that no person except the person who was born in a specific manner of specific parentage could hold the office of the presidency. And we're going to show you exactly, historically, what that meant. Remember again, they had this book in their hands constantly before they wrote the Declaration of Independence, which was 11 years before the letter went from John Jay to George Washington, 2 weeks before the signing of the Constitution, which said, let me hint that it be wise and seasonable that we not allow our government to be infiltrated by foreigners, and that only the presidency devolve on somebody who is a natural-born citizen. So let's find out, what is a natural-born citizen. At 212, chapter 19, Vital's Law of Nations. The citizens are the members of a civil society, bound to this society by certain duties and subject to its authority. They equally participate in its advantages. The natives, or natural-born citizens, are those born in the country of parents, with an S, plural, parents, who are citizens. As the society cannot exist and perpetuate itself otherwise than by the children of the citizens, those children naturally follow the condition of the fathers and succeed to all their rights. The society is supposed to desire this in consequence of what it owes to its own preservation, and is presumed as a matter of course that each citizen, on entering into society, reserves to his children the rights of becoming members of it. The country of the father is therefore that of the children. The country of the father is therefore the country of the children. And these become true citizens merely by their tacit consent. In other words, they don't have anything to say about it. It just is because that's nature's law. A child, which we all know, doesn't have a right of anything until they become the age of majority, 18 years old. You follow what your father says, or you don't have the right. It's why you don't have the right to do a lot of things when you're a child, because a 2-year-old can't make decisions about what they're supposed to do. So they follow the natural course is their parents are the rule. We shall soon see whether on their coming of the years of discretion, they may renounce that right. In other words, when you're born that way, you do what you want. When you become of the acceptable age of making decisions on your own, you have the right to denounce it. But until then, you are what you are, following the way of the Father as far as citizenship is concerned. And what they owe to the society in which they were born. In other words, they can renounce it and they can say, well, I don't owe anything to this society, and therefore I'm going to step out of it and become a free person, and I'm going to denounce my citizenship. I say that in order to be of the country, it is necessary that the person be born of a father who is a citizen, for he is born there. For if he is born there of a foreigner, it will be only the place of his birth and not his country. That's very important when it comes to Mr. Obama. Very important. You want to be historically right, then understand what the phrase natural born citizen means when it's used in the Constitution. Don't be ignorant and don't be stupid. Wake up and pay attention to the history. I'm going to show you exactly how we knew 100 years after this that a Supreme Court judge knew exactly what this meant. In Minor versus Happersett, which again, people are going to say it's not relevant because it was about the tying of constitutional rights to voting rights. But that's not necessarily what we need to look at. What we need to look at in that case is what the judge said when he was describing citizenship. Because it's very important that the Judge Gray, in Minor versus Happersett, 88 U.S. 21 Wall 162, 1874, folks. 1776, Declaration of Independence. They had in their hands constantly the book that I just read from. 1787, you get a letter from John Jay saying that we should have no one except a natural born citizen be the commander-in-chief of the United States Army. Okay? You understand that? 2 weeks before the Constitution was signed. Nobody but a natural born citizen. In 1874, almost 100 years later, Judge Gray says this. And it's very important that I have to read to you more than just the relevant part about what a natural born citizen is, because it's going to show you almost word for word he's citing Vital. If they weren't relying on Vital, why is a Supreme Court judge citing almost word for word what Vital said? Okay? Let's read what he says here. Before its adoption, and this is at page 88, U.S. 165. The case again, Minor versus Happersett, 88 U.S. 21 Wall 162. Supreme Court case. Okay. Before its adoption, The Constitution of the United States did not in terms prescribe who should be citizens of the United States or of the several states, yet they were necessarily such citizens without such provision. There cannot be a nation without a people. The very idea of a political community, such as a nation, implies an association of persons for the proclamation of the general welfare. Each one of the persons associated becomes a member of the nation formed by the association. He owes his allegiance and is entitled to its protection. Oh, gee, doesn't that sound familiar? Doesn't that sound familiar? Let's go back to Vital. Let's go back to Vital again. As a society cannot exist and perpetuate itself otherwise than by the children of the citizens, those children naturally follow the conditions of the father and succeed to the rights. The society is supposed to desire this as a consequence of what it owes to its own preservation and is presumed as a matter of course that each citizen on entering the society reserves to its children the rights of becoming citizens and entitled to the same benefits. Isn't that what he's saying right here? Oh, wow, that's awful funny that the judge 100 years later is citing almost verbatim the reason for it, which comes from Vital. Okay? For convenience, it has been found necessary to give a name to this membership. The object is to designate by title the person or the relation he bears to the nation. For this purpose, the words subject, inhabitant, and citizen have been used, and the choice between them is sometimes made to depend upon the form of government. Citizen is now more commonly employed, however, and as it is considered better suited for the description of one living under a republican government, which is what we are. We are not a democracy. We're a republic. It was adopted by nearly all of the states upon the separation from Great Britain. Oh, gee. It was adopted by all of the people on their separation from England. All of the states decided that citizen was the word instead of subject. Subject when they were British, citizen once they got away from Britain. Oh, that's pretty interesting. And was afterward adopted by the Articles of Confederation. Before the Constitution. They knew that the people who were living here in the Articles of Confederation, which bound the states together as independent states, not under a federal constitution yet, but they still understood that there were citizens and not subjects. When used in this sense, it is understood as conveying the idea of a membership of a nation and nothing more. So a citizen is a member of the society, but nothing more. Okay? All right. Let's go on. To determine then who were citizens of the United States before the adoption of the amendment, the 14th Amendment they're talking about here, because that's where this woman was trying to say in her lawsuit that voting rights under the 14th Amendment were somehow entitled to her. And just to give you the finding in the case, voting rights are not tied to the Constitution. Everybody has a right to vote, but not just because you're a citizen. If that was the case, then when you became a felon, they couldn't take your voting rights away. So we know that it's not a constitutional right. Otherwise, we couldn't infringe on them by taking them away once you're found guilty of a felony. But they are entitled to all citizens, providing you meet the requirement. They can't be taken away that way. But just because you're a citizen doesn't mean that it's anyway in the Constitution tied to voting rights. Okay. That was the finding in the case anyhow. But that's not what we're concerned with. What we're concerned with here is what he says about natural born citizen. And again, I read to you Vital, and here 100 years later we have a judge citing that. So don't play stupid with me and act like history doesn't tell us what that phrase means. And it means that the Constitution today, without being changed, says exactly the same thing it said when it was written and adopted, which says that no person has the authority to hold the office of the President of the United States and Commander-in-Chief of the United States Armed Forces unless he was a citizen at the time of the adoption, which is over 200 years ago, and I know ain't nobody alive now that was 200 years old yesterday or tomorrow. So you'd have to be a natural-born citizen because that's the only other kind of citizen that's allowed to hold the presidency. So the natural-born citizen is a very important thing. Be intellectually honest here, folks. This is a constitution we're talking about. To determine then who were citizens of the United States, I'm reading again from Justice Gray. To determine then who were citizens of the United States before the adoption of the amendment, it is necessary to ascertain what persons originally associated themselves together to form this nation and what were afterward admitted to membership. Now we're going back to the original document. We're going back to the original document. What does that phrase mean? Looking at the Constitution itself, we find that it is ordained and established by the people of the United States. And then going further back, we find that these were the people of the several states that had dissolved the political bonds which connected them to Great Britain and assumed a separate and equal station among the powers of earth. So what he's reading from there is the Declaration of Independence, or what he's citing there. It's pretty clear. Okay, because that's what it says. I mean, go back and read the Constitution, the Declaration of Independence, and that's what he's saying. He's saying the same thing that we said in the Declaration of Independence, that they decided to sever their bonds, the political bonds that held them together, so they became independent states. We, the people of the United States, became separate from Britain. We were no longer subjects, we were citizens of the United States, even though we weren't under a federal constitution. We were a group under the Confederation of states that held their own constitutions, but we were all citizens, okay? Citizens, not natural-born citizens, because once again, if there is no country that you could be born in yet, if you were a citizen of the United States and you were born as a British subject, you couldn't be a natural-born citizen because there was no country of the United States to be born a parent of. I mean, it's only logic. Let's be intellectually honest here. If you're a citizen, that's why the phrase in the Constitution says what it says. It says that unless you were a citizen at the time of the adoption, that's the grandfather clause, because they knew themselves that they couldn't hold the office of the presidency if they said only a natural-born citizen, because they themselves weren't natural-born citizens. A natural-born citizen was a person who was born in the country of parents that were citizens of that country. Well, they were citizens of the country because they formed the country, but they couldn't have been born of parents that were citizens because there was no country before that. So there you go. Looking at the Constitution itself, we find that it is ordained and established that we, the people of the United States, and then going further back, we find that these were the people of the several states that had before dissolved the political bonds which connected them with Great Britain and assumed a separate and equal station among the powers of the earth, and that they had by Article of Confederation the perpetual union, in which they took the name the United States of America, entered into a firm league of friendship with each other. In other words, the states were in a firm friendship with each other, but they were still independent states, but they were bound together by a confederation with each other for the common defense and security of their liberties and their mutual and general welfare, binding themselves to assist each other against all force offered to or attack made upon them. Oh, in other words, those states got together, which were the original colonies, the 13 colonies, the 13 states, made a pact to go against England and help protect each other against an attack from the people they were breaking away from. It makes good sense, doesn't it? Okay. Or any of them. On account of religion, sovereignty, trade, or any other pretense whatever. Again, this is Judge Gray, Supreme Court Justice, 1874. Whoever then was one of the people of either of the states when the Constitution of the United States was adopted became ipso facto a citizen. Okay, that's all they could be. They couldn't be anything else. They could only be a citizen. Because again, when they understood the term natural born citizen, they knew themselves not to be natural born citizens, as I explained already. If there was no country existing that they were now citizens of, if their parents couldn't have been in that country that they were citizens of, then they couldn't be born of parents that were citizens of that country. Therefore, it disallowed them from being a natural born citizen. The best they could be would be a citizen. Therefore, the grandfather clause in Article 2, Section 1, Clause 5, that says a citizen at the time of the adoption of the Constitution. That's how they got themselves in. Because they couldn't be natural born citizens. They were protecting for the future, though. They became ipso facto a citizen, a member of the nation created by its adoption. He was one of the persons associating together to form the nation and was consequently one of the original citizens, not natural born citizens, citizens. As to this, there has never been a doubt. Disputes have arisen as to whether or not certain persons or certain classes of persons were part of the people at the time, but never as to their citizenship. If they were additions, might always be made to the citizenship of the United States in two ways. First, by birth, and second, by naturalization. Then we'll jump down here to page 88 at 167. Additions might always be made to citizenship in the United States in two ways. First, by birth. Second, by naturalization. This is apparent from the Constitution itself, for it provides that no person, except a natural-born citizen, or a citizen of the United States at the time of the adoption of the Constitution shall be eligible to the President. Office of the President. No person, except a natural-born citizen, or a citizen of the United States at the time of the adoption of the Constitution. How about that? The Congress shall have the power to establish a uniform rule of naturalization. Thus, new citizens may be born or they may be created by naturalization. The Constitution does not in words. This is Judge Gray again, Supreme Court Justice. Does he know the law? Did I just show you that he was almost verbatim quoting Vital in his understanding of how a society is bound by it, it perpetuates itself by its citizens, and how the citizens are bound to it by their responsibilities, and until they become a person of majority, they are naturally a citizen because they follow the rights of the father. They follow the rights of the father. Okay? The Constitution does not in words say who shall be natural born citizens. Resort must be had elsewhere to ascertain that. Okay, so if it doesn't say it in the Constitution and resolve has to be found elsewhere, where else would it be found? In the documents which I just told you, the Vital. That's what they were quoting. That's what they had in their hands when they formed this country. That's what That's what John Jay, the first Supreme Court Justice, had in mind when he said, let me hint whether it be wise and seasonable that we put a strong check against the admission of foreigners into the administration of our national government and not allow it to be given to or devolve on any person, the commander-in-chief not devolve on or be given to any person who's not a natural-born citizen. Okay? The Constitution does not in words say who shall be natural-born citizens. Resort must be had elsewhere to ascertain that. At common law, with the nomenclature of the framers of the Constitution, okay, nomenclature. That's the word used to say how we go about using words to describe things we're familiar with. When we say a car, we know what a car is. That's nomenclature. The nomenclature is that a car is a car. A truck is a truck. A boat is a boat. Nomenclature. The words we use to define things. The nomenclature for the word or the phrase natural born citizen. What was the nomenclature associated with that phrase at the time? Again, 100 years after they were reading the signing of the Constitution, 100 years after the Declaration of Independence, after they'd had Vital in their hands with the Congress now sitting at the time of a rising state, while they were writing the Declaration of Independence and forming a new nation, they knew what that was because of the book Vital. Here we've told you he's verbatim writing down, a judge 100 years later is writing down what the reason was about how a society perpetuates itself by the citizens and that they follow the right of the okay, and then, okay, here we go again. And this is his words, not mine. Let's be intellectually honest here. Let's follow history so that we're clear on this. Things got murky after this. That's why we're in this situation. At common law, with the nomenclature of which the framers of the Constitution were familiar, it was never doubted that all children born in a country of parents who were its citizens became themselves upon their birth citizens also. These were natives or natural born citizens. Gee, where did I hear that before? Let's see. Vital, chapter 19 to 12. The natives or natural born citizens are those born in the country of parents who are citizens, as a society cannot exist or perpetuate itself otherwise than by the children of the citizens, and those children naturally follow the conditions of the father. Oh, that's Vital. Here's Judge Gray, Chief Justice Gray, that in the nomenclature which the framers of the Constitution were familiar, it was never doubted that all the children born in a country of parents who were citizens became themselves upon their birth citizens also, and these were the natives or the natural born citizens as distinguished from aliens or foreigners. Some authorities go further and include as citizens children born within the jurisdiction without reference to the citizenship of their parents. As to this class, there have been doubts. There still are. There's doubts. If we go with people who are born in the country in no regard for their parents, there's doubts about their citizenship. Because again, let's go to the 14th Amendment. All persons born or naturalized and subject to the jurisdiction, not born in the jurisdiction, subject to the jurisdiction. Let me ask you something, folks. Is a Mexican who comes across the border and illegally and arrested, do we have a right to do anything to him, or do we have to let him see a consulate? If we have to let him see a consulate, guess what? He's not subject to our jurisdiction. The only way you become subject to our jurisdiction is by requesting it or by legally paying taxes. because you become subject willfully. You don't become subject just because you're born on our land. You're an illegal intruder is what you are. And again, let's go back to Vital and we'll understand that too, because it says here in Vital, let's go back to Vital about this issue. It is necessary that a person be born of a father who is a citizen, for if he is born there of a foreigner, it is only the place of his birth and not his country. It's the place of their birth, not their country. Okay? Child doesn't have a... Okay, here again. If they were already subject to it, why is it that when an illegal comes here and he brings his kid, the kid can't apply for citizenship, the father has to? Why is that? Anyway, let's get back to the birther issue, because it's not really, when they say birther issue, you're trying to make it simply about where he was born and not the nature of the birth. Okay? So let's go back to this again. As to this class, which I was saying again, in the jurisdiction without reference to their parentage. As to this class, there have been doubts, but never as to the first. Okay? So there's never been a doubt when he's talking about the first. Let's go back and see what the first was. When he's talking about the first that he described. Okay? The Constitution does not in word say who shall be natural born citizens. Resort must be had elsewhere to ascertain that. At common law, with the nomenclature of which the framers of the Constitution were familiar, it was never doubted that all children born in the country of parents who were its citizens became themselves citizens upon their birth. They were the natives or natural born citizens as distinguished from aliens or foreigners. That's the first. There's never been a doubt. Never been a doubt. There wasn't a doubt in the mind of the people who wrote the Constitution that in order for you to hold the presidency, you had to be born in this country of citizen parentis with an S, plural. Okay? Just so we got it clear. So let's not be intellectually dishonest here and try and say that this is a racial thing, because it's not. It's a purely legalistic thing. If you want to go ahead and say, oh, President Obama showed his birth certificate and it shows he was born in Hawaii and therefore he's a citizen, I'll buy that. He's a citizen. Is he a natural born citizen? Sorry, not according to this. According to this, his father would have had to have been a citizen, and his father was never a citizen. His father, if you believe the birth certificate, his father was Barack Obama Sr., who was a citizen of Kenya, which was a British protectorate, which under the 1948 British Nationality Act made him a British subject and therefore not an American citizen, and therefore it doesn't matter where Obama was born, he couldn't meet the requirement because he was not born in the country, which he may be, but not of two parent citizens following the way of the father. And that was the nomenclature. Let's put it to rest, folks. There's no racism involved here. The reason I understand this is because I'm the person who in 2009 brought a lawsuit against Obama saying that he wasn't eligible for the ballot. And if you look at my case, there's another name on there for the same exact thing, John McCain. Was I racist against John McCain? Was I racist against John McCain? John McCain was born in Panama. He wasn't born under the jurisdiction of the United States. His father was a citizen. His mother was a citizen. They may not have been married at the time legally, but it doesn't matter. He wasn't born in the United States. Even if he was subject to it, he wasn't born in the United States. He was born in Cologne, Panama. Again, you want to try and bring a case against me, Mr. McCain, for slander? Let's see your birth certificate and see where it says, because in my lawsuit against you, your lawyer threatened that he would destroy me because you had evidence that you were born somewhere else. Where's the evidence? Somebody's word? or the documents. You never said in your case against me that, in my case against you, that the document I showed was a fictitious document. You simply said you had evidence to show he was born somewhere else. So there goes your racism argument. Stick it. It ain't racist. It's a legal issue. And if you think that us having somebody who does not have the loyalty to the United States sitting in charge of our armies is a good thing, then let it go. If you think it might be a problem, then it needs some more investigation. That's what I say. Later. Oh yeah, just another little PS, side note. Uh, if you don't think that the law of nations had anything to do with the Constitution, just so you know, at Article 1, Section 8, Clause 10, under the authority of Congress, uh, check out where it says that they have the right to define and punish piracy, crimes on the high sea, and crimes against the law of nations. What's the law of nations? The book, Vital. It's in there. You tell me what that crimes against the law of nations might mean. Okay? Thanks.